order. If I could get everybody to take your seat, and let's have the Sergeant at Arms close the door once we get going. There's a lot of times a good bit of noise out in the hallway, and I'm told we're going to have us a concert sometime around noon today, so we're going to try to wrap our business up within a couple of hours so we're not listening to a brass band play as we talk. The first thing on our agenda is to approve the minutes from our last meeting. Believe it or not, it was back at the end of March of this year, so I'm going to give everybody just a couple minutes to review the minutes, the draft of the minutes, so we can take a motion to approve those. Give you a minute or two. All right, does anybody have any questions, or is there a motion?
So, Mr. Chairman, I'll make the motion.
All right, I've got a motion and a second. Motion by the Vice Chairman, Senator Dolezal, and a second by Senator Kennedy. Any discussion on the minutes? All right, all in favor of approving these minutes as drafted, raise your hand. And are there any opposed? All right. They are hereby adopted. I thought I'd take a minute to let everybody know what our agenda is this morning. I think it's important for us to remember the purpose and the scope of this committee's actions. You know, it all came to light through some of the public attention brought to Fani Willis and her alleged misconduct during certain prosecutions and also the running of that office. That is something that we are to look into, but at the end of the day, what we are charged with doing is not persecuting her in any way, not trying to disqualify her from prosecutions. That was left up to the court system, which has acted at this time. But we are investigating essentially a broader issue of misconduct and also the impact that has on our citizens' faith and confidence in the fairness and impartiality of our judicial system. And so we're charged with looking into existing laws and determining whether any amendments are necessary or any new statutes are needed to restore that public confidence in our criminal justice system. In order to do that, we've been given authority to subpoena witnesses to testify, as well as subpoena documents, and we've been through quite a few of those in the last year or so as we have engaged in our duties. This morning, you have in your folder the subpoenas where we subpoenaed Mr. Ian Heap. He's the Executive Director of the Prosecuting Attorney's Qualifications Commission. And I thought it would be good for our committee and the public to get a little background information on that body, that commission, when it was created, who's on it, what they do, and what they've been doing. You have noticed in the press there have been conversations or mentions in rulings about the appearance of impropriety by District Attorney Fani Willis and perhaps others. But there's maybe a little vagueness as to what that means, and I want us to get some clarity. And Mr. Heap, I'm going to let you kind of help educate this committee. I have in your folders, people, I have a code of conduct for prosecuting attorneys. I also have the rules of the Prosecuting Attorneys Qualifications Commission, and I think if you don't have it yet, you will get a copy of the underlying statutes that created this commission and laying out the duties of various prosecutors in the state. So at this time, I'm going to invite Mr. Ian Heap to the, I guess we'll call it the witness stand, but the podium here, if you will, and I'm going to swear you in, and then we'll let you testify before the committee. Mr. Heap, if you will raise your right hand, please. Testimony you give in this matter be the truth, the whole truth, and nothing but the truth, so help you God. All right. Let me make sure I got your mic on. Try a test there, make sure we can hear you.
Is my microphone on?
You got it. You're going good. All right. You're sworn in. If you would just please introduce yourself to our committee and any observers, and let us know your position and your role and just a little background, if you don't mind.
Sure. My name is Ian Heap, and I am, depending on which document you look at, either the director or the executive director of the Prosecuting Attorneys Qualifications Commission of Georgia. I want to put right out front that I am a detail guy. I'm a legal wonk. I go long. If I'm going long, throw your hand up in the air and I will shut up. You say you want to be out of here by lunch, you need to let me know, okay?
Okay.
And you've asked me a very open-ended question, a lot of stuff in there, so I'll try to unpack it. The Prosecuting Attorneys Qualifications Commission was set up by statute. There were several attempts to do that. Early on, it was, and I know this is you know, y'all work together, politics, whatever, but originally there was a bill sponsored by Democrats to create a prosecuting attorney oversight, which was fueled by, and you spoke earlier about sort of a focus on District Attorney Willis. Early on, there was two district attorneys, two Republican district attorneys that were drawing quite a bit of political fire. And that measure failed, and then the oversight was revamped into a qualifications commission, which was then codified and was set to go into effect in 2023. However, there was a line in it that stated that it was our rules would only become effective if they were reviewed and approved by the Supreme Court, which was patterned after language for the Judicial Qualifications Commission, which is the oversight for the judicial appointments in Georgia. They are the underlying authority is more clear constitutionally. They have several amendments that spell out quite a bit about them. The Prosecuting Attorneys Qualifications Commission is constitutionally authorized by a line in the Constitution, but without much definition. And so when the Supreme Court was asked to review and approve the rules, they opted not to, citing they weren't sure that they had jurisdiction, and that the language of the statute did not require them to. It said that it would become our rules would become operative when, but didn't say that they shall review, so they chose not to, and actually threw in a lot of language about whether we were judicial branch, executive branch. They split up between what branch you are in and what functions you carry out, and I'm actually putting 2 or 3 decisions together here, reading the tea leaves of several decisions saying that prosecutors in general, and that we, as an extension of that, are clearly in the judicial branch through funding and appropriations, et cetera, but do not conduct any judicial functions, that our functions are executive, and so it's quite a issue for the courts, and that we downstream have to deal with. All that being said, in 2024, this legislature passed another law which took out, it took out one line. It said, we're taking out the line that says the rules have to be submitted and approved to the Supreme Court. Once that went into effect, the commissioners, and I'll explain the commissioners in just a minute, adopted the rules and advertised for the position of, they advertised for executive director. I interviewed for executive director, was hired as executive director. However, the statute says director. That's why I introduced that I'm one or the other, depending on whether you look at the statute or my onboarding papers. And so that was April of 2024 that the rules went into effect. That's pretty important because of time jurisdiction, which I'll get into in a second, and like I say, just redirect me with a question when I'm
All right,
driving
well,
you nuts.
let me sort of restate what I think you've just told us in a very detailed manner. In 2023, we created the Prosecuting Attorneys Qualifications Commission, and that's under OCGA 15-18-32. That original version went into effect, I suppose, I think the effective date was March 13th of 24. It was set to be effective. I remember we had a delayed effective date, but we delegated to the Supreme Court the right to pass the rules and regulations governing the commission. I think we gave them some time to do that. They then came back and said, we don't feel like it's appropriate for us to be setting rules and regulations for this commission. And I don't remember all of their explanation. We thought they would have because they have the control over disciplining any attorneys in the state of Georgia, which in our view included prosecutors, but they had some hesitancy because of separation of powers in that case, if I remember. So that's when we went back in 24, and we amended it to take the rulemaking authority away from the Supreme Court and essentially leave it up to the commission. Is that close to the way this played out?
It's a fair statement.
Okay. When was the commission appointed, and who appoints the members of the commission?
The commission itself, excuse me, the commission itself is divided into two panels. There's an investigative panel and a hearing panel. The investigative panel consists of 5 members and is in charge of basically running the day-to-day business of the Prosecuting Attorneys Qualifications Commission and conducting investigations that are brought to it by the public, although it can raise its own complaints. There are 5 members. One is appointed by the governor, one by the lieutenant governor, one by the Senate Committee on Appointments, and 2 by the Speaker of the House.
Do you know when they were appointed? When did we get up and running? Because they had to be appointed before they advertised for an executive director position, which you received.
They were up and running. Well, they were appointed and in their positions in 2023. And they actually did advertise for a director or executive director at that time, but did not hire because at the creation of the Prosecuting Attorneys Qualifications Commission, a lawsuit was brought by several individuals who would be subject to the potential discipline, and they filed for an injunction which would stop the commission from doing anything. My understanding, again, this is before my time, but my understanding is that they made the decision not to hire staff and begin to spend money when they didn't even know if it could run. Right. That added to the Supreme Court opting not to adopt the rules, effectively left them dead in the water for almost a year.
Right. Then we came back in and we cleaned that up, took the rulemaking authority away from the Supreme Court, and we gave it to the commission itself.
First of all, I defer to your analysis, but I don't see it as taking the rulemaking authority away. The commission itself was to draft the rules themselves with input from the Prosecuting Attorneys Council, which is another entity, get input from them and draft the rules, and then they were to be sent to the Supreme Court not to make rules but to review and approve.
That's right. It said such standards and rules shall be effective only upon review and upon adoption by the Supreme Court.
Right.
And that's what we took out.
Yes.
So that they could we leave it solely to the commission itself to pass the rules and regulations.
After they themselves were submitted, received the proposed and opted not to, and said that they weren't even sure that they legally could. They said they legally weren't bound to do it, and even if ordered to, they didn't know that they could.
So after all that legal wrangling, your commission published rules and regulations. We have a copy in our folders today.
Right.
Right?
What
And-
they did was, upon that decision of the Supreme Court, they simply voted to adopt what was sent. So they didn't rewrite anything, they didn't change anything. They said, this is what we submitted to the Supreme Court.
Right.
If they're not going to review it and the legislature deems that they don't have to, we're going to adopt it now. That date is very important as far as jurisdiction.
Right. And my memory is we were trying to appease the prosecutors by having a judicial review of the rules and regulations that were going to govern their conduct. And that's, we were trying to get the Supreme Court to bless it. They said, we're not going there, and so we removed that requirement. One way or other, are these the rules and regulations that you guys are following now, that you provided in response to our subpoena?
Yes,
Okay. And you were hired as the executive director of the commission.
I was.
The format of it seems to almost exactly mirror the Judicial Qualifications Commission, which has the authority to investigate and discipline and sanction judges who violate their codes of conduct or specific rules and regulations. Is that a
There are
fair?
many similarities. There are a few fairly serious distinctions.
All right. Well, tell us what's happened since you got hired. When did you assume your position?
I was hired, I got my letter in early July. I began drawing a salary August 1st. I was kind of working both my old job and trying to get running for the new job because the budget for the next fiscal year, et cetera, was all due September 1st,
And you're talking about in 2024?
2024.
Okay, so you've been on the job a little bit over a year now.
Yes.
Okay.
Correct. When I came to the position, we had nothing, zero. We didn't have computers, we didn't have an office, we didn't have staff, we didn't have, all we had was the statute, the rules, the code of conduct, and appropriations, and as I found later, our appropriations were attached to the prosecuting attorney's counsel, so we had their assistance in administrative tasks, fiscal tasks, and HR tasks. Like I say, I needed to set up an office and get things running. I first hired an executive assistant. The agreement, when I was offered the position, was that the administrative office could be set up anywhere. And they said, whoever we make the offer to, you can set it up wherever you want to, because you're not actually going to have meetings there. The commissioners are across the state, and the potential witnesses and subjects are all across the state, and we're going to have it in the geographical center of gravity. If you've got 5 commissioners on the investigative panel, it might be there. If you've got 3 on the hearing panel, the hearings might be here. So I said, if I can set it up in Savannah, I will. As outlined and documented in the annual report, Savannah was unique in 2024 as having a less than 2% vacancy rate for commercial office space, unlike many cities where it was in the 20s and they were having foreclosure. Getting office space was very difficult. In addition, we had to get secure office space because of significant security concerns across the judiciary. The JQC had to move into a secure office because of security concerns.
Let's kind of cut to the chase. Where's your office? I don't need to know about the lease negotiations and all that.
It's in Savannah. What
Okay.
I'm pointing out is that in itself was a Herculean task, and we got help from the executive branch they didn't have to give us, which was very favorable. We set up shop. I advertised for and hired an investigator with considerable experience. I was given a folder of hundreds of emails that had accrued between the creation of the passing of the first bill and my coming aboard, of which I had to sort them out and find out how many were purported complaints, how many were citizen contacts, et cetera. Although there were several that purported to be complaints, none of them met the statutory guidelines. The statute itself sets up very strict requirements, such as there has to be an affidavit. None of the original submissions had an affidavit, except one that was from what the courts call a sovereign citizen, and the affidavit had nothing to do with what was in the complaint. It was just some sort of UCC thing. Doesn't matter. Point being is, I had to sort through those, communicate to everyone who had purported to file a complaint that it didn't qualify. That doesn't mean we wouldn't consider it if you submit a new one that meets the requirements. We spent a lot of time and effort putting together a website that would guide somebody through specifically how to file a complaint. If they go through the website process, it has fields to fill out so that everything that is required is at least asked of them. It makes it very clear that there has to be an affidavit attached. Also, if they are submitted through the website, they get a receipt of their submission when they sent it. They can prove that they made a submission, and they can prove what they sent or what they didn't send. We can prove what we received when we received it. That website went into effect. Then we started to get complaints that we could actually consider. I've mentioned several times the adoption date of the rules. This is vital because the commission themselves voted before I came aboard. They voted that they would not consider conduct that occurred prior to the adoption of their rules. The statute sets out that they would set up rules that were in keeping with due process, and they considered, based on due process, I think of it more like an ex post facto, is you can't consider a violation before you have rules in effect that explain, and there's some argument about that, but that's not my decision to make. That was a vote of the commissioners, and they did put out a release that explained that. So conduct that occurred prior to April 1st, 2024 will not be reviewed by the commission unless it is part of an ongoing pattern that continues past that date. And there is quite a bit of consternation among complainants, et cetera, that we're not going back and looking at things that happened in 2021, 2022, 2023. But by statute, we don't have jurisdiction anything before the inaction, before 2023, and by vote of the commission and the actions of the Supreme Court's adoptions of the rules, April 1st of 2024.
All right, so that's our start date, so to speak. After
Correct.
2 years of fits and starts, we finally got you a building, we finally got you elected,
Yes. We then-
hired. We've
Right.
got 5 members of the investigative panel, and are there 3 other members that are the...
3 of the hearing panel.
hearing panel.
The hearing panel has nothing to do with anything unless and until formal charges are filed. It's specifically patterned after the revamp of the JQC so that the entity that's hearing the case to decide the case doesn't have any foreknowledge of that. It's a pretty clear separation. I did mention that there's a few distinct differences with the JQC and the PAQC. One of the big differences is that the JQC's hearing panel, when they finish, just draft, when they've had their hearing, all they do is draft, not all they do, it's a considerable amount of work, but they have a lengthy trial. I think there was just a very public one here. they draft a report, and they send that report to the Supreme Court, and then the Supreme Court actually does the sanctioning or whatever the appropriate measure is. In our system, that is all done by the hearing panel, and then they merely report that, but the sanction or not has already been imposed. We haven't gotten to that yet. And then there is an appellate right. It can get to the Supreme Court, but the Supreme Court doesn't determine whether this is worth a censure or involuntary retirement. That's decided on the hearing panel level in our system.
Okay, and that is a 3-member hearing panel.
That is correct.
That is part of your commission.
Yes.
One is an elected district attorney or
Yes.
solicitor that's appointed by the governor,
Yes.
and one is a former judge of a Superior Court or the Court of Appeals or a Supreme Court justice with at least 10 years of service.
Yes.
And that's appointed by the Speaker. And then there's another elected district attorney or solicitor general that's appointed by the Senate Committee on Assignments, and they end up being the presiding officer of that panel. Is that as you understand it? 'Cause
That is correct.
All right, so this gives heavy influence to the prosecutors that are being overseen, basically. On the hearing panel, 2 of the 3 members are district attorneys or solicitors general.
By statute, yes.
Right.
In reality, the judge who is on there was also a longtime district attorney, Howard Sims. So there's 3 long-term district attorneys on that hearing panel.
So essentially, the prosecutors are governing themselves under this commission. Any determination of adverse consequences, a censure, any other type of sanction up to involuntary retirement is left up to, as of right now, 3 active or past prosecutors.
Correct. By statute, 2 active prosecutors and a superior or a judge in
Right.
current practice, 2 current and 1 past, long-time career prosecutors, yeah.
Right. Okay. And so that's who's making the decisions. You were not really in business to accept complaints till April 1st of '24. That's a
Right.
year and a half ago now. Tell us what's happened in the last year and a half. Have there been complaints filed with the commission, and have they been investigated and acted upon?
Yes. There have been many complaints. I guess that's a relative term. Initially, we got a bunch of complaints from people resubmitting what they had previously submitted. Then there was a lull because, quite honestly, not many people knew we were out there or what we did. And one of our problems has been getting out there what we do. We've actually attempted to, we've done press releases that only one outlet has carried. We tried to get linked to government and non-government sites. Nobody has much interest in linking back to us, so we do what we can. But in 2023, we had 7 complaints filed. In 2024, we had 36 complaints filed. This year, up to date, I believe we are on 86 complaints. So you can see a snowballing, an increase.
Are these confidential in nature?
Yes, by statute, by the statute that, well, obviously you all passed, all matters before the investigative panel are confidential unless and until they were to come up with an agreement, a consent discipline. And there is actually one now public action out of the investigative panel, which is both on our website and which has been published on the Supreme Court website. But that is the only thing that is permitted to be released.
That would be the consent agreement can be released if the prosecutor agrees to certain sanctions.
Right,
Okay.
right.
One of those, I turned that up because of lawnmower outside.
Okay. I just caught a heck of an echo.
I'll turn
I'm
you
sorry
back
about
down
that.
as soon as they finish up in front of us.
Okay.
All right, and so does that investigative panel have the authority to enter into those agreements?
And I realize already that you understand what I started with, that I get way down into the weeds, but
All right,
they can do certain matters by consent. There's other matters they can't do by consent. There's some they can do by consent, some of which are required to remain private. For example, if it was a deferred say it was a substance abuse issue, and the agreement was, we'll defer as long as you complete inpatient treatment, whatever that is, then that would remain confidential. But if the agreement, such as the only one that's public now is you have already stepped down, you will agree that you will not seek any elected or appointed district attorney or solicitor's office forever, we'll suspend the investigation. That is, not only can be public, that is to be public, and it is to be filed with the Supreme Court, who graciously accepted to publish it. I mean, based on our rules, I think the argument could have been made they didn't have to, but they did. And as a backup, I've written into the agreement that it would be published on our website, but it's now in 2 places. But no, mostly not. The distinct change comes if the investigative panel at the end of a full investigation directs the director to file formal charges with the hearing panel. At that point, everything becomes quite public, and there's policy explanations of why it is that one is to be very private, both for the security of complainant, whistleblower, whatever, and the possible retaliation, whatever. It was written in there. And the flip side is the district attorney, if it's been dismissed, if it's just rumor and slander, whatever, then that should not be put out in the public either. However, once a determination has been made that there are sufficient facts to warrant a formal charge, then the citizens of Georgia deserve to know what's going on in the process, so that they have some, open government, some clarity, some faith.
okay. So my understanding is these complaints generally have to be under a sworn affidavit of some sort, so that they're serious, and that they must allege misconduct that's prohibited by the statute.
Absolutely.
Okay. I'm looking at subparagraph 8H of 151832 that lists the grounds for removal from office or involuntary retirement from office, being mental and physical incapacity that interferes with the performance of their job duties, willful misconduct in office, and for an attorney, district attorney, willful and persistent failure to carry out their duties that are prescribed by statute. Same thing for a solicitor general, their willful and persistent failure to carry out their duties under the statute that applies to solicitors general. Conviction of a crime involving moral turpitude, or conduct prejudicial to the administration of justice, which bring the office into disrepute, or finally, knowingly authorizing or permitting an assistant district attorney or an assistant solicitor general to commit any act above, basically. So these are serious type offenses that give you jurisdiction over potential removal from office of a prosecutor.
Yes.
And they can be brought, so if somebody brings them, they have an affidavit that's a sworn statement of their personal knowledge of these violations, and they can put whatever other documents that they want to support the claim, and that then goes to the investigative committee to do their investigation.
No.
Okay, what happens then?
It does not go to the investigative panel at that point. It goes directly to me,
Okay.
at which point I carry out several step process. The first is I review it to see if it is what I call a sufficient legal document. If there's no affidavit, it's not going to the investigative panel.
Okay.
first, officially, we're going to dismiss it and say you can file again. Realistically, I asked one of my investigators, can you call this person and tell them they don't have an affidavit, right? See if they can get that done. If they can't, okay, so that's the first thing is no affidavit. No affidavit is a non-starter because that's right in the statute, got to have it. The second is if they don't identify an elected prosecutor over who we have jurisdiction. Some of them just say, a prosecutor, and, could be anybody.
They don't know them by name, or it's not specific enough for you to...
Right, or they want to complain about a municipal prosecutor in the city court of Swainsboro with traffic tickets. I'm not saying specifically, I just pulled that out of it. That's in no way revealing anything.
Okay.
Or say the Attorney General, or a U.S. Attorney. We don't have jurisdiction. So if they don't name a person that we have jurisdiction over, have an affidavit, they have to allege one of those specific items, and they have to have some facts. If they have those things, then it's what I call a legally sufficient document, at which point I will look at it. At which point, and again, if not, we don't just tear it up and laugh. We contact them. We send them both an email and a letter that states, this is what's wrong. If you can remedy this, reapply.
If it is procedurally sufficient,
Right.
what do you do with it?
Okay.
You vetted them to make sure they got the affidavits, that their own personal knowledge, that they allege one of these grounds of misconduct.
Right.
Then
And
what
a
happens?
surprising amount don't meet that standard, by the way.
Okay.
People do have a confusion over who we have jurisdiction over a lot. Anyway, but I'll move ahead. So the next thing that I do is I look at it, what I would term as, and I guess I dodged your first question, who am I? I was a prosecutor since 1994. That's what I do. I didn't plan on doing this. I didn't plan on being anything but a prosecutor for my entire life. And I did this. I wasn't looking for a job. I was asked to put in my name to do this. And I did this because there was going to be a new creation that would greatly impact my calling and the calling of most of the people I care about. And it could go a lot of ways. And if it was going to get done, it was going to get done right. So I'm running my last lap doing that. Okay?
Back to my question.
Back to the
If
question.
you've cleared it procedurally,
Right.
what do? Do you throw it in a trash can? Do you hand
No.
it to a deputy?
No.
Do you give it to the investigative panel? What do you do with
No,
it?
I look at it on what I call, the break is what I would call, as a prosecutor, the Jackson versus Virginia standard, which is if I take everything that they say to be true, and some of it obviously isn't, but for this analysis, we look at if everything they say is true, and if every inference that could be made is made to the benefit of the complainant, could this support one of those aforementioned bases, okay? And if that's possible, then it gets what's called a preliminary investigation. If it's not possible, then there's no reason to do a preliminary investigation, because if we prove everything that they say, it's not possible.
Do you have employees that are investigators that do that, or does it go to the investigative panel to do that investigation?
I do the screening myself. Once the screening is done, I then task, I started with one, but because of the growing number of complaints, we brought on another investigator. I have 2 investigators, and I task them specifically with sometimes just saying, can you track down these 2 or 3 things, like an affidavit, or this all hinges on this one transcript, can you get the transcript? But if there's a preliminary investigation required, I then have 2 investigators, which I say generally do a preliminary investigation, but I also add in specific things that I find to be turning points to the investigation. It's going to hinge on these things, please focus on these things.
Do they report back to you what the findings of their preliminary investigation are?
They do.
Then what do you do?
At that point, previous to this, I could screen anything out and just send letters, notification letters. If there has been a preliminary investigation, I then take this to the investigative panel. Well, the first thing I do is I write a report, a director's memo. I take the investigator's report, the director's memo, and all of the documentation that we've assessed, and I make that available to the members of the investigative panel in a secure electronic method. And then during our regular meetings. We go into executive session because it is confidential. They have had weeks to review my recommendation, the report of my investigator, and if they want to go back and check our work, they can do that too. And we bring each one of them up for discussion and vote, and they decide to either authorize my recommendation, which would either be, at this point, authorize a full investigation or dismiss it. And then when they've done that, if they dismiss, then I send out dismissal notifications. If they authorize a full investigation, we move into a different phase, obviously, which is still confidential, but is more overt, because at this point, we have to actually contact witnesses. And no matter how many times you tell a witness you can't say nothing about anything, some are going to say something. So it's going to get out. You know, if you go to a courthouse and start getting records, you can say, why are you doing that? You know, we don't have subpoena power, which is a huge issue, but so we have to do Open Records Act. If we file an Open Records Act and it's my investigator, it's pretty clear what's going on. So
are your concerns there for the reputation of a person that's a prosecutor that might have a false claim against them or something that doesn't warrant any sanction?
It's both.
Okay.
It's always both.
When do they learn about it? Let's say I'm the DA. Do I learn, where along the process am I ever advised that there's been a complaint filed against me?
As it stands now, if it's dismissed any time prior to authorization of a full investigation, you don't.
So I'd never even know you did the due diligence and your investigators say this is a bogus argument. Somebody's just unhappy with their sentence or that they got prosecuted or whatever.
Right.
Okay.
Nobody knows about it.
But if it goes to the full panel.
If it goes to a full investigation, then within 10 days of that decision, I notify by mail and email the subject prosecuting attorney, notify them there has been a complaint, what the basis for the complaint is, what who the complainant is, unless the panel specifically addresses and votes on that it should be kept confidential for some reason. They're offered the opportunity to meet with either myself or the panel or both. So they can request that. We give them the opportunity to. We can request that meeting. We can request a written response, and that's all sent to them. So at that point, they know what's going on.
Okay. And then they have a hearing, I presume, and they're able to present their side of the case?
No.
Nope?
No.
Okay, what does this panel do if they don't ever have a hearing?
So the investigation goes on, and part of the investigation is, again, either a meeting at our request with the prosecutor or at the prosecutor's request, at which point that's like their opportunity to tell their side of the story, to explain. They've been told what the charges are, who the complainant is, all, and they have an opportunity to present. Or it's an opportunity to talk about, well, if this is true, what are we looking at? Is this deferred? Is this a censure? Are you looking to, and they can decide that. The other way that they get to present their side of the story, if you will, is through their written response. Again, they've gotten a explanation of what the complaint is and such, and between the written response and the any meeting that occurs is, quote, their side of the story. Then the investigation, the rest of the investigation is done, done in a report and then a memo, and at the appropriate time, the investigative panel looks at what they have from the investigation and what, if anything, the prosecuting attorney says, and decides what they want to do. Do they want to direct me to file formal charges? And you say if they don't have a hearing, there's specifically a hearing panel, and that's what the hearing panel is for, the hearings. And so it would get sent to them, at which point the public charges would be filed and everything would become open. So what do? They review, first of all, they run all of the affairs of the office. They review, they delegate to me to do the work, and then they review my work as far as just all the stuff that needs to be done, setting up budgets, all that sort of stuff. But they also look at every case that has had a preliminary investigation and decide where to go from there. And then for every one that's had a full investigation, they then revisit that for a much larger, hopefully, file, because after a full investigation, they should have quite a bit more to review to decide whether or not that then gets sent to the hearing panel, which again, because of the separation, that hearing panel knows nothing about the case to this point.
Okay. Well, are we finally to the hearing panel? You've gotten all this investigation, you've vetted it, it's been done, they've had their say-so, and you decide there's enough there to take it to a hearing panel. Right?
I recommend whether there is or not. They decide. It's a majority vote of a quorum of the investigative panel.
Of the 5 investigators. So they get your presentation, we'll say to them, and they decide this is worthy of us having a hearing on it.
Yes.
All right. Now,
Okay.
that takes a long time, it sounds like.
If we're doing our due diligence, yeah.
Okay. So you had 36 of them in 2024. How many of them got to that point in the game where they are going to be heard in front of a hearing panel? I have a report from you,
Right.
your 2024 annual report, but spare me to have to
Right.
read it all.
There have been, not only through 2024, but through today,
I'm not asking about today. In 2024, you had 36 complaints.
none.
None of those ever even had a hearing in front of the hearing panel.
No.
Now, in 2025,
Yes.
this would only cover misconduct after April the 1st of 2024.
Correct.
Okay. You've had 86 complaints.
That is
Now, how many of those have been referred to the hearing panel for a hearing? That made it through all those steps you just told us about to be worthy of a hearing?
none.
0. Okay. All right. I'd like to, you to refresh us on what are the possible sanctions or punishments or penalties that the commission is authorized to impose. You've mentioned censorship, censor somebody. You've also mentioned you can force involuntary early retirement. What are the other steps in between there?
Well, there's a wide variety, and most importantly, there is a catch-all at the end that says, or anything else they feel appropriate.
Okay.
But it can be anything from oral counseling for a very minor offense. It can be censure, it can be,
That's just like a public letter saying you were a bad boy or girl. You breached some duties, right? Nobody wants that on their record, but doesn't take them off a case or doesn't get them
No.
suspended or nothing like that. All
Right, and there
What's
is-
the next step after that? What else could you do?
I haven't memorized them, and I don't want to give you there can be a temporary removal or a temporary ban from prosecuting or removal of certain functions. And then there is the involuntary retirement. Interestingly, the involuntary retirement, if done by the hearing panel, is a 10-year bar, but if it's done by consent, it is a lifetime. But again, there is also deferred, and we've discussed that earlier, where if it's based on certain conditions that could be rehabilitative, they could get a deferred sanction, which may never come to light. So really, it's a continuum, and
Right, I got the first end of it, a censure, and I got the final end of it, making them retire. What's in between on this spectrum of potential punishments? I'm looking at 15-18-32 M. That says there could be a public reprimand, censure, limitation on the performance of prosecutorial duties, suspension, retirement, or removal. That's the only place where I see a listing of what the powers are, and I wonder if we're relying solely on this statute, or whether you have rules and regulations that give you a wider spectrum or a more specific spectrum of
The
punishment.
The rules do list considerably more than that.
Okay. Now, you really, you hadn't found anybody, let's just say, to be misconduct through the hearing panel. But have you reached informal agreements with them through the process you just described, where there have been certain prosecutors that agreed to a reprimand or a suspension or a retirement without having to go to that formal hearing?
There is one publicly disclosed consent disposition of a Solicitor General who agreed. When we received the complaints, the day after we received the complaints, he submitted his resignation to the governor. We then had to decide whether to go forward or not. We reached the agreement that, and our rules in the commentary under the discipline, commentary 9 and 10 read in conjunction, state that if a prosecutor steps down, then the PAQC investigation doesn't go on. However, there's also an agreement that is filed, whereas they agree not to. They can't just step down and then, as soon as we shut things down, run in the next town over.
Right.
And so that is set out in detail on the filing in that case.
So the 3-member hearing panel has really never had a hearing?
They have not.
Okay. Ever since the creation of this commission?
That is correct.
I guess some of these 86 pending complaints could work their way up to a formal charge and by the investigative committee, and then a hearing by the hearing panel to impose suitable punishment.
I can tell you generally that there are cases that are in full investigative status and have not reached the decision of what to do. So potentially any one and or several of those could result in a hearing after any meeting, either regularly scheduled or specially called, of the investigative panel.
And I understand that the commission itself can generate a complaint. You don't have to wait for an aggrieved citizen or attorney to bring one. The commission itself can initiate an investigation.
The statute specifically says that it doesn't bar them from doing that, yes.
Has the commission itself, up until this point, ever brought a complaint of its own?
I think, and I'm sorry, I want to answer your question, but I want to make sure that it's not violative of, I think I could say, okay.
You don't have to
no,
tell me the
No,
name.
we haven't. I just wanted to make sure, okay. No, the investigative panel has not initiated a complaint, nor have they instructed me to initiate a complaint.
Okay, because it reads, nothing in this code section shall be construed to limit the ability of the commission to bring a complaint pursuant to this code section on its own motion.
Right.
So what you're telling me is up until now, the commission has not brought a complaint on its own motion against any prosecutor.
That is correct.
Okay. There's also a provision that allows your commission, or I guess maybe the hearing panel, to issue formal advisory opinions on your own initiative. Have you issued any advisory opinions letting prosecutors know your thoughts on what is inappropriate behavior that's perhaps not included in the statute? Because you mentioned that catch-all.
Right.
Any conduct prejudicial administration of justice or whatever that's kind of broad. Have you given any guidance to the solicitors general and the district attorneys as to what the commission might consider to be inappropriate or grounds for discipline?
I have not issued any director's opinions, and the hearing panel has not issued any official opinions. There's two options and neither one of them has been exercised as of today.
Did the commission, through its rules and regulations, give any more specificity as to what type of actions are misconduct other than what we see in 15, 18, 32H, those 7 grounds? Have your rules and regulations, in other words, gotten more specific than the statute that we passed in 23 and amended in 24?
As far as what is prohibited or actionable, I believe not. I do believe that it needs to be read in conjunction with the Code of Conduct, which gives a little bit more definition. And in fact, as far as the, because actions of assistant district attorneys and assistant solicitor generals is a particularly thorny issue, you have to prove that they knowingly authorized or allowed the action, and that's not specifically clear in the statute, in the rules. However, I believe in the Code of Conduct, it says that negligence is not sufficient to meet that standard.
Okay. So tell
And
me
again,
about,
the Code of Conduct was written before I came on board. So.
what is, who prepared this Code of Conduct? Is that statutory, or is that through somebody's rules or regulations, or the State Bar of Georgia? Where did these rules of professional conduct come from? Or
They
Code
were
of Conduct?
adopted by the Prosecuting Attorneys Qualification Commission. I do not personally know who authored them.
Okay. That's okay. The commission is responsible for it. Whoever was
Yes.
the draftsman, doesn't matter. Okay. All right. And so that's clear out there what is expected, the Code of Conduct of prosecutors.
The Code of Conduct does, I believe, clarify and expand on, and I don't think changes in any way. I think it also mentions specifically sexual harassment, but I mean, it's pretty clear from the first and last basis for sanction that you can't do that.
Anything in there prohibit a supervising attorney from having sexual relations with a subordinate contract attorney?
I don't think that's specifically laid out.
Okay. Do you consider that improper conduct or misconduct?
I wouldn't want to speculate or offer an opinion on future. Everything is very fact determinative.
But just to be clear, there is no pending investigation of Fonnie Willis in your commission, is there?
I don't think I could answer that if one
Okay.
existed or one didn't exist.
All right.
I just don't think I could answer that.
Because it would be confidential.
Under the statute specifically, if no consent agreement has been reached and no formal charges have been filed, I can't talk about it.
Which-
If it were to exist or if it weren't to exist.
Would she even know if there was an active investigation going on at this time?
If an investigation on any prosecuting, commissioned prosecuting attorney reached the full investigation stage, they would receive a 10-day letter unless the commission also specifically voted that there were actual reasons to delay notification. So if one went to full investigation, then any prosecutor who was under investigation would know. There is one more little rub, too, is we're having a huge problem with confidentiality as far as our complainants go, and our complainants will go in the paper or on press or, 1,000 ways on social media, YouTube. We had a YouTube guy who would go on YouTube and talk about this, and he had a monkey. So he had a lot of followers because it was funny.
If you do an investigation and you get through those stages, but don't do a formal referral to the investigative committee, do you ever advise the accused person that, hey, you had a complaint, we looked into it, there's nothing to it, just to give you a little peace of mind, you might have heard this on social media, but we have terminated your investigation?
Well, that's where I'm going specifically. If
Okay.
if there is public, if the complainant has basically put it out there, then we believe it's fair and incumbent to then contact the prosecuting attorney directly and say, based on this social media or this newspaper article or whatever, there may be an investigation of you. And again, we have to work very carefully within the statute, but the statute allows the prosecuting attorney to waive confidentiality. Now, they can't waive confidentiality if they don't know, so we send them saying something is, this is out there. If it does exist, if you want to sign this waiver and send it back to us, then we will let you know what's going on, because it's only fair, and then you may choose to respond in public or not. It's not a waiver as far as they complain, and so we ask them to waive so that we can then dump everything into the press. That's not the point. It's, again, fairness of they are abusing the confidentiality, the way the confidentiality is written, and I'm not sure how you could even rewrite that to affect.
Well, that's one of my next questions for you, is how can we improve this law? And if confidentiality is a weak link, tell me how to fix it.
It is. That's a very
All right?
thorny
What
issue.
what should we do? Put penalties on somebody that breaches the confidentiality? Should we open it up to be more transparent to the public? Is there a particular fix that you want us to consider that we could do statutorily? You're the man. You handle them all.
Okay.
You screen them for procedure,
Right,
and then
right.
you got two investigators that screen them for validity, let's say, or
Right.
reasonableness. So what do you want us to do, if anything?
Well, if anything, I humbly ask that you give us subpoena power, because right now we're basically, as far as an analysis of, law enforcement, we're not law enforcement. We're basically delegated to Tier 3 investigations. We can only have consensual contact. We can ask people, and if they don't want to talk to us, they don't have to. They don't have to come in. Witnesses don't. Nobody has to give us any documents. We have absolutely zero authority above what an average citizen
How
has.
would a subpoena power ensure confidentiality?
It wouldn't, but
Okay.
I was not going to answer a question of what can you do without telling you what I think the most vitally important
Well,
thing.
I'm going to get to that. I'm going to let you
Okay.
give all your grievances and anything you want this committee to consider. Right now, I'm focused on
I got
confidentiality
you.
because you brought that up.
And confidentiality is a huge issue, and right now, it is there to protect both sides, but the real issue now is what I believe is unfairness to the prosecuting attorney, because again, there is nothing to stop the complainant from publishing the fact that they filed a complaint. Now, following up on that, there legitimately have been situations where not only have they publicized that they have filed a complaint, but they then will, say, post or read on YouTube or by whatever method they do, like my response saying, we've received your letter and you'll be contacted by an investigator in such and such a time. And whereas their complaint is their speech, I don't think that it's appropriate for them to be publishing the actions of the commission. So those are two entirely different things.
You mean your final determination should not be published? Say you,
Well, whether
for lack of a better term, disbar a prosecutor. I'm thinking the parallels to
Right.
you and judicial qualifications, if the
Right.
judge is removed from office, and the State Bar of Georgia disciplinary procedures. Bar complaints made, it follows the same kind of plan
Right.
that you're saying here. It ultimately gets determined, and then the Supreme Court issues the sanction.
Yeah.
They print them. They publish them. Anytime a lawyer is suspended or disbarred or censured, reprimanded, that is made public. Or you've never gotten there yet, but if you guys ever do find somebody to have engaged in misconduct, would that be published, or
Well,
doesn't the public have a right to know?
it does get published if it goes to the hearing panel and any discipline occurs.
Okay.
It's
Just hadn't done it
it's
yet.
very public. And again, there's certain other things that are public. There's currently pending Senate Bill 218, which has undergone some changes and is currently back to the Senate.
That's in an agree-disagree posture because it was changed in the House. And we have not agreed with those changes yet, so that's
Right.
still pending
Right, no,
legislation.
exactly.
Right. So you have given us this, your year-end report for 2024.
Yes.
Because that's the only really full year y'all have had yet. And we're not through with 25. In your
Right.
recommendation section, you said that your commission will be addressing at the upcoming legislative session confidentiality, which you and I are talking about now,
Right.
search warrant and subpoena authority, physical safety, recruitment of future directors, the appeals process, and anything to clarify, the date limitations of the law.
Right.
Okay, you just addressed confidentiality, but you haven't told me specifically what you want. You're dealing with
Right.
a lot of legislators right here. All of us are members of the Senate.
Right.
This bill is in the breast of the Senate.
Right.
So what do you want us to do on confidentiality from a statutory standpoint?
On confidentiality, the prosecutors themselves, and I've spoken to groups of elected and appointed prosecutors on more than one occasion, and I'm not saying every one of them, but the general consensus is they want to know as much as possible as soon as possible. So they do not like not knowing that there's a complaint out there against them. They do not like not knowing who the complainant is.
Have you considered changing your rules for that, or is that statutory?
It is statutory.
Okay.
And again, I've had some input. It is your legislation, and you all draft it. I have had some input into 218, and there are several things in 218 that address it. There is a provision that upon a dismissal of any complaint, that the prosecutor be made aware that there was a complaint, the nature of the complaint, and the disposition. Not the name of the complainant or the specific facts. And I think that's, in my opinion, the cleanest way to walk that tightrope, because you've got competing interests, right? But I think they deserve to know if a lot of people are complaining, if nobody's complaining, what type of complaints.
Got it. I've heard enough on that.
Right,
And I
okay.
know what you want, and we can look at that. You keep getting back to the search warrant and subpoena.
Oh,
That's
okay.
the biggest bee in your bonnet.
Yeah.
Tell us, you don't have that power now. Tell us why you need it or want it, because that would be addressed in the legislation. People don't just have subpoena power, these independent commissions, without us granting it.
Absolutely.
Okay, so why do you want it? And
This-
tell us about it.
I'll tell you why I want both of them, and I'll tell you why subpoena power we pretty much have to get, or it's
You've
not.
been getting the records from open records requests or voluntary submissions.
That's, and
Okay.
voluntary discussions.
Are you attempting to get records that you're being obstructed?
I will.
That the accused prosecutor is saying, heck no, you can't see my emails, or I'm not going to share my correspondence or my files with you, or whatever.
Without getting into any specific case.
I don't want you to
I
ever
will
get into a
say-
specific case in
I
front of
will
this
say
vote.
that there are documents that we have believed would be very important to investigations that we could not get under our current structure.
All right, so you couldn't get them through an open records request,
Correct.
okay?
I will also point out that there are several appellate-level decisions with prosecutors fighting open records acts in some form or another.
We're familiar.
There was, the Gonzalez case came right out of the Supreme Court.
That's why I'm familiar. She was from Athens.
And so,
Refused to comply with open records request. Was found
again,
in contempt, and all our appellate courts upheld that prosecutors
So-
must comply with open records requests, right?
And open records requests don't get you certain classes of documents.
Okay.
It only deals with, well, you're familiar, but something else that's important that I don't think people consider when you're talking about subpoena power is the Constitution of the United States deals with subpoena power for defendants, okay? They should have the right to be able to compel witnesses
Right.
in their own defense.
And the Fourth Amendment also protects against unreasonable searches and seizures and requires subpoenas to be issued to take somebody's documents, invade their privacy, and that has a level of judicial review, where the prosecutor doesn't just send a subpoena. They go to the judge and ask him to approve that, or the search warrant or whatever, right? I mean, how do you want yours to work? I would imagine the prosecutors want a little bit of protection from willy-nilly subpoenas. Now, they're probably not very worried. You've already said you're an ex-prosecutor, they're your colleagues, your friends, you're part of why you want your job is that. All these panels are stacked with majority
Right.
of either DAs or solicitors, so it's a little bit of the fox guarding the hen house to start with, but if they don't want subpoenas.
No, I don't think.
Are you going to have some judicial approval of your subpoenas if you seek one? To show probable cause or not?
I'm unaware of who you've discussed it with or what input you've had. The input that I've had.
Well, they're lobbying too. You mentioned in your
No,
report
I'm
you guys are
saying-
going to lobby,
I'm saying-
and trust me, they're
I'm saying
aware.
I've had no pushback on subpoenas whatsoever.
Okay.
I met with an elected district attorney, the head of the Solicitor General's Association, and the head of the PAC, and the author of the bill, and talking about how they would absolutely not want search warrants, but they
Right.
didn't mind subpoenas.
Maybe I'm confusing.
So I don't think that subpoenas are a controversial issue,
Okay.
number one. And I could be wrong, there could be people out there, but I don't believe that to be true. As I stated, if we were to have a hearing and they did not have the ability to compel witnesses to attend for their defense, I mean, you got to look at both sides.
Gotcha. So what did you mean by physical safety? You had listed in your year-end report you had concerns about physical safety that you wanted to be handled through legislation of some type.
I do. You had previously asked about search warrants, and I could give you a few seconds on search warrants, or I could go to, but search
Do
warrants,
you want the ability to do search warrants?
I believe that search warrants for records is vital.
That's different than a subpoena for records?
Yes. It used to be that you could get medical records with an ex parte order. The Supreme Court said that a couple of years ago that the only way to get medical records is with a search warrant. And there is no, even if a law enforcement agency were to try to do it for us, they could not do it because we're not investigating a crime. They're not evidence of a crime. What they would be evidence of is incapacity. Half of our job is to investigate incapacity. Incapacity is, medical, and we cannot get medical records without a search warrant, period, in Georgia. So without and I lost the battle of perception in this because it got turned into, I believe, in people's minds, that he was going to be out there with a Bearcat and a SWAT team hitting the DA's office and going through their filing cabinets or their houses. And it wasn't written that way. It was written records from third-party providers, never to go after the attorney, but say bank records if there were an allegation of bribery. Phone records, right? How do you get those? And most importantly, medical records. However, again, I lost the battle of perception clearly in that. I am a rookie at most of this stuff. So that's search warrants.
Okay.
I don't think subpoenas is a big deal. I doubt now that we're going to get search warrants, but it's all up to you.
all right.
So moving to your physical safety question, because again, I know I'm driving everybody crazy, and you guys
No,
are going to have to
it's
edit this down.
11:15, you're doing good. I've got a couple other subjects I'm going to get into,
Right.
but you're doing good.
Okay.
I think you're educating us as to how this process works, and that's what we're trying to do. And if I'm sounding adversarial to you, playing devil's advocate, I'm not poking at you. I'm just trying to elicit from you the information I think we need to understand how
no.
this process works.
No,
Okay.
I'm just very self-conscious about the fact that I go long and down rabbit holes, and I apologize, and everybody's time here is very
All right,
valuable.
let me steer you back to physical safety then.
Right. So physical safety, again, this was written back in 2024, the end of 2024, and pointed to specific things such as the JQC literally had to move their building. They had to break a lease and move their building to get behind state troopers not because judges were upset and come in to get them, but because I think some of the anecdotal stories were people whose children were taken in a custody case and they wouldn't sanction the judge, or a divorce, you know how contentious those things get. And so they were coming and saying, you know, I can't believe this person ruined my life and you would do nothing, and we're going into the office and creating issues.
Into the prosecutor's office,
No, into the JQC's office.
JQCs.
JQCs, the regulating body. So what we have is, we have people upset about the actions or perceived actions, or wanting to influence the actions of what they consider an oversight commission, one way or the other.
So you're worried about prosecutors barging in, and you're also worried about complainants barging in?
I am absolutely not worried about prosecutors barging in. What I am worried about are people on either side of the issue saying, so-and-so sent my son to prison on forged documents, and you said you're not going to do anything about it. You've ruined my life.
Okay.
I'm going to end yours.
So you and members of the commission are worried about your physical safety because of these unhappy people?
Yes.
All right, and what do you want us to do about that? Make it a law against violent threats against you guys, or you want us to give you a security force?
No.
What's the solution?
The two things that I had specifically placed in the, or had asked that the legislature address were, number one, giving my investigators very limited powers of arrest. Because when the citizen's arrest law was removed, roundabouts 2020, no one can detain except for security guards, shop owners, oddly enough. But so if someone were to come to the office of the PAQC or the parking lot when maybe my administrative assistant is walking to her car, or if we are holding a meeting or hearing at a location, and like I say, we'll hold them all over the place, and if it's not at a secure courthouse or something, you know, we have used a county commission building, okay, and that wasn't secure. It wasn't a courthouse. It wasn't secure. I want my investigators to have, again, very limited ability to arrest people only for crimes against the person or property of a commission member, employee, witness, or accused.
All right.
Only on those specific premises or traveling to and from, and specifically, I mean, it's very carefully drafted, not to include any crime that may be under investigation, just those things.
Right.
And then the second, because my people aren't post-certified law enforcement. We are not law enforcement. We never, there's no argument that could be made that we are law enforcement. We don't enforce laws. So then the second issue is the exemption from 1611-130 is exemptions from 126 through 127.2 firearm statute.
Okay. So you want them to be able to carry a weapon?
I carried a weapon
Okay.
for my 26 years prosecuting,
simple
and
enough.
when I retire, I'll be able to, but for this particular 2 or 3 years, I can't, which is odd.
All right, so I got it. You want your certain employees of your commission to have arrest powers and to be able to carry a firearm in the course of their job, right?
I want my 2 investigators, who are both, by the way, post-certified because they're prior jobs,
Okay.
and would have to be able to have limited powers of arrest. And I want them, myself, and my commissioners to be able to be exempt from the certain firearms restrictions.
Got it.
Now, that was a huge blow-up because it was amended to every lawyer could carry in every courthouse, and that's why it was cut out and doesn't exist anymore. Again, another one where it just got, and here's the thing is we get subpoena power, you can cut out the guns, you can cut out the arrest, you can cut out clarifying whether I'm a director or executive director, you cut the whole thing out. I just need subpoena power, but I really need subpoena power.
All right. And I had one other note that I saw in your recommendations or suggestions was in the budgeting process, and you're fortunate to have the appropriations chairman, Tillery, here on this panel. Your commission is in the same line item, so to speak, or the same area as the prosecuting attorney's council?
They have graciously already taken care of this for
All
me.
right. So you're effective lobbying without even having to change the statute.
Well, I didn't mean to point out.
Your budget was under
No,
the prosecuting attorney council's or something like that?
When I first came on board, I believe there was one piece of legislation that controlled what I was doing. Senate Bill 93, which became, 15, whatever. So, and there's one mention about PAC in there that they would assist in drafting the rules. That was it. When I came on board and started to figure out, okay, well, how am I going to buy computers? Because I need computers and I need a cell phone, right? What do I do? Where's the money? And I found out that it all goes through PAC. And I said, well, where is that in this law? And they said, oh, it's not, it's in the other law. And I was like, the other law? I'm sorry, I'm getting way too close. I'll
Your
calm down.
problem's been solved, right?
We were attached to the prosecuting attorney's council in appropriations because we don't have enough people.
And are you no longer attached to them?
No, they took care of this for me.
Good.
Not for me,
All
for
right.
us.
Well, we've solved your
Moved
problem.
to AOC. They're charging us less than a quarter of what the PAC had charged us to do our administrative work. It removes all of the conflicts. It's just
You happy about that?
overjoyed.
All right, let's move on then. I need to ask you, and this is not specific to any pending case or potential case, but I want to know, in your opinion, is a prosecuting attorney's violation of the Victims Protection Act misconduct that's prohibited by this code section or your rules and regulations?
So we're talking about the Crime Victims Bill of Rights, AKA Marsy's Law, is that correct?
That's correct.
Okay, without
Senator
going
Kennedy,
into
I think, passed it.
Right, without going into any
right.
specific case, we have received several complaints about that.
Is that a dereliction of duty to fail to comply with that, to fail to notify victims and consult with them prior to a sentencing or a plea bargain deal being arranged with the accused party?
Right, I'm sorry, I didn't mean to cut you out.
Yeah.
It could be, there would have to be some proof that the district attorney directed that to occur, because we can only discipline district attorneys, not assistants, not victim witness coordinators, not et cetera. There is an argument to be made that if it were to show a pattern, but then again, there is language in the Code of Conduct that says that negligence is not sufficient, and I don't know where we would get an email that says, don't tell the victim what happened. I'm pretty sure they wouldn't release that for an Open Records Act.
Do you think the prosecutors should comply with the Victims Protection Act? I call it. You're calling it the Bill of Rights.
I believe that everyone should comply with every applicable law,
Right.
and that we're all supposed to be the good guys, right?
Intentional failure to comply would be misconduct in office? Intentional or knowing?
That's
Okay.
a pretty, very fact-specific, because again, it would have to be the district attorney doing that. And then there's also...
No, it could also be knowingly authorizing or permitting an assistant district attorney to do it.
Right, so...
Because district attorneys don't go to court on every case. They're a supervising attorney, basically, right?
Right, so again...
If they know their assistant's failing to comply with that law and they're permitting it and authorizing it, is that misconduct? This isn't complicated.
Well,
If violating a state law is not misconduct, then I see why none of your people have ever been disciplined yet. I mean, where you've had 100 and something complaints and nobody's even
Right.
gotten to a hearing. If you're not considering a violation of a statute, misconduct in office, knowing violation of it.
well, and that's where it comes is we have to be able to prove.
And that's why I'm saying, I don't care about anybody's name or image or likeness or who we're talking about. In general, if you had a complaint against a prosecutor for knowingly violating the Victim Protections Act, would that be misconduct in office? It's proven without a doubt.
If it's proven that the person who we have jurisdiction over
True.
violated the law, then yes, it could fall under probably one of three different categories.
All right. And what about the Open Records Act? You mentioned that earlier. What if a prosecutor knowingly, willfully refused to comply with our laws on Open Records Act and did not provide duly requested documents? Is that misconduct in office?
If it were proven that the district attorney themselves did or knowingly authorized, then yes, it could be considered, like I say, one of several.
Okay. Now, what about pursuing a case for personal profit, where the prosecutor can be shown to financially gain from the prosecution? Would that be misconduct in office?
It could be, and there's specifically language in the statute that exempts that from the discretionary protection in individual cases.
Okay, in 1832I2, for those taking notes, there are allegations, if it's plausible the district attorney or solicitor made or knowingly authorized their decision in office on undue bias or prejudice against the accused, an undisclosed financial interest in the outcome of the prosecution, or an undisclosed conflict of
Yes.
interest, those are grounds for punishment, right? For sanctions of some sort?
No, and that's what I was talking about earlier. They're not grounds for punishment. What they are exceptions to a blanket defense of discretion. So in individual cases, not general cases, but in an individual case, it's a defense that they are exercising discretion, which they're allowed to. But
So-
if it's shown, right,
Right.
that there's financial interest, that removes the discretion defense
Okay.
from the action.
And that's the broad term of prosecutorial discretion. They get to decide which cases have sufficient allegations of wrongdoing with sufficient evidence to convict to decide which one to prosecute.
Right, and what to plea and whether to put it on a calendar and all those
So
things.
if somebody's bringing a complaint on the basis of them making a decision whether or not to charge somebody with a crime, a plea offer, whether or not to grant a continuance, whether to put a case on the trial calendar, to set bond, et cetera, those are generally prosecutorial discretion that it is not our business to interfere with, right?
Exactly.
Okay. But there are exceptions.
Yes.
In doing any of those things, if it's shown you're using it for bias or prejudice against somebody, or you've got an undisclosed financial interest or an undisclosed conflict of interest, or other factors that are completely unrelated to the duties of prosecution, then you're not exempt from sanctions or punishment for doing your prosecutorial duties.
Exactly.
Okay, good enough.
Exactly.
Have you had any of those kind of complaints? Bias, conflict of interest? Financial
Again,
interest and outcome?
I think probably I'm getting caught in the details, but those aren't actually complaints. Those are ways to overcome the defense of discretion.
Okay.
And so we have generally, not any one specific case, but generally we have complaints that have been on specific cases. And then we have to look at, okay, since it's a specific case question, then we look at, does it fall within discretion, or is there a way to negate the
Okay.
discretion? So we have,
You've dealt with the issues
I have
peripherally.
looked at that specific analysis more than once.
Okay. Do you agree that it is improper conduct to engage in prosecutions when you have undisclosed conflict of interest or undisclosed financial interest, or you're biased or prejudiced against the defendant? Or are you going to say that's a case by case? If it's proven, let's say the
Well, no,
prosecutor admits it.
No. It's clearly there's something wrong with it, which is why it's in there. And then it's fact determinative. Was it intentional? Was it an oversight? Was it a miscalculation of what it's considered? Is it flagrant? Is it the driving force behind it? Is it, there's, yeah.
Okay.
But yes, people should not be prosecuting people because they don't like the defendant or because they're going to make money if it goes one way or another. That's why it's in there, yeah.
So now, there's also a policy here, and I think this might have been aimed at the district attorney in the Western Circuit, Athens, Clark County and Oconee County, a stated policy, written or otherwise, which demonstrates that the district attorney or solicitor general categorically refuses to prosecute any offense or offenses of which he or she is required by law to prosecute. And we had a DA that said, I'm not prosecuting drug charges unless you're distributing. If it's personal
aware.
use, you have your heroin, have your marijuana, have your alcohol, whatever it is. And this makes it clear that that is an abuse of prosecutorial discretion, just to say, I'm not prosecuting certain type of crime. Right or wrong?
Well, first of all, it's sanctionable because it's in there. It's in the law, yes.
This makes it clear that you can't use a blanket
Right.
agreement not to prosecute certain offenses as prosecutorial discretion.
Well, and that's where I guess, you know, I'm got to quibble with you. I think it's an abandonment of discretion. I think it's saying I'm not going to exercise my discretion.
Right.
I'm not going to look at each case.
And is that-
And there's prosecution discretion allows prosecutors to say, based on this person's situation, this person's record, and yes, they had marijuana in their pocket, but for some reason, I'm not going to
That's right.
prosecute this case.
Case by
That's-
case, but if you say, I'm
it-
not going to prosecute marijuana possession, that's a different deal, right?
Exactly. So
Do you
it
think
goes
that's
from-
misconduct?
It is under the statute, yes.
Okay.
But again, it's what it is they're not exercising the discretion that they're required to exercise. They can not prosecute the case, but they have to decide that.
We're arguing the same point. I just want you on record saying that's misconduct. We don't expect our prosecutors to refuse to prosecute laws that our legislature passes just because they don't like the law, irregardless of the facts of any
Right,
particular
yeah, no.
case.
Like
Okay.
I say, that's why I say we're quibbling over details, but yeah.
I have heard you talk about codes of conduct. Of course, you're familiar with the Code of Professional Conduct for Attorneys that's set forth in our bar rules and regulations. Do you expect prosecutors and assistant prosecutors to follow those rules? Rules of professional conduct and our disciplinary rules that the state bar applies to all attorneys?
When you say, do I expect, if the question is the violation of one of those a sanctionable offense, I would say that it is if it can then be fit within misconduct in office or conduct which brings the judicial system into. So yes, they can be subsets of one of the 7, or depending on how you count them, because there's one that's just, anyway, they can be definitions of and fit within the subsection of those
Understood.
bases, those statutory basis of what can lead to discipline.
So one of those professional requirements of all attorneys is the duty or obligation of honesty and candor with the court. Would dishonesty before a judicial proceeding constitute misconduct? It's clearly a violation of the bar rules.
Well, again, I don't want to prejudge any particular case or...
Well, you need to let these prosecutors out there know what's right and wrong. So you might as well help them here and let them know that that's something that you would deem to be misconduct if proven or agreed to.
It's something that would, if a complaint were received, it was something that would then be analyzed. Okay, number one, is this misconduct,
Let's just say knowing and intentional misrepresentation.
Right. But you look
Okay.
at number one. Does this fit within basis number one? Does it fit within basis number? Well, it's not incapacity, so it's not going to fit in that. But is this, action which draws the judiciary into disrespect? Is it?
Yeah,
Does
okay.
it fit within one of the things?
How about other false reports like on ethics notices or requirements to disclose certain gifts or benefits? Would a misrepresentation, knowing misrepresentation on those type of reports be
Right.
actionable?
Well, that would be the same analysis. Again, if it's wrong, then just wrong in the right or wrong, then it's looked at, is it going to be official misconduct in office? Is it going to be behavior which, but at this point, I think it's important to look back. Our rules cite In re Coomer pretty carefully and repeatedly, because it is one of the few court decisions that really goes and explains, it deals with the JQC and actually in its interactions with other things such as the ethics.
What's the name of that
panel.
case again?
What?
What's the name of the case you're citing?
In re Coomer.
You got that, Mr. Counsel? We've got our counsel,
He's-
Josh Belafonte here. I'm sure he's well.
Mr. Belafonte is familiar with In re
We will
Coomer.
provide copies of that opinion to our members as we continue our deliberations. Okay.
So
Anything else you want to tell us where you've, did I cut you off? Go ahead.
But the important thing in re Coomer, and there's a lot of stuff in there, and it's used to define many of our terms, is that if you have an action which falls under several jurisdictions, for example, in re Coomer, there were ethics violations, campaign finance violations, and they were the subject of a consent decree, consent agreement, whatever the JQC does, where they agreed that violations had occurred and there would be, voluntary sanctions. That can be, but does not have to be, a basis for the JQC, a separate agency, to then take that and see that as a violation of the JQC. So if there is a violation, they could leave it with the primary jurisdiction body, or they could use it as the basis for a separate matter. Does that make sense?
That does. So I'm just looking at 151832H6, and you've mentioned this: conduct prejudicial to the administration of justice which brings the office into disrepute. It would seem to me, knowing misrepresentations or lying to a judicial tribunal would bring the office into disrepute. It would certainly undermine the public's confidence in the fairness of a prosecutor if they're lying in court under oath. So
Yes,
you
and
would
that's-
agree that's misconduct that would certainly warrant an investigation to get to the truthfulness of it,
Yes.
the accuracy of the claim.
Yes, it's worthy, if it's worthy of investigating whether or not that fits into Section 1, Section 7, whatever. And then, again, there's, I probably should make this clear, that whatever I think, I make recommendations that's then voted on.
That's why we have you here, to make recommendations
Right,
to
right.
us. If these are not clearly prohibited
Yeah.
by this law today,
Yeah.
we're going to try to come up with a law that makes that clear.
Right.
Because I don't think there's anybody in the state of Georgia that believes a elected prosecutor ought to be lying in court, especially when your physical freedom is in play, where you may go to jail based on somebody lying or
Right.
misrepresenting things in court.
Right.
That's why you don't have confidence in the fairness and impartiality of the system.
Right.
Well, that's one way. And so I'm asking you, basically, at the end of the day here, do these categories, these 7 that we have laid out under subparagraph H, adequately address the types of misconduct that you're seeing complaints against, or would you like us to add something more specific so that it's clear that you shouldn't be having sexual relations with essentially an employee that you're paying, and that you shouldn't be dishonest in court, that you should comply with the Victim Rights Act, and that you should comply with Open Records Acts? If we need to add subparagraphs 8, 9, 10, and 11 to add those, we can consider that. And we're asking you to tell us what you need to be more specific, if anything. You might come in here and say, you know what, I don't think you ought to disqualify somebody if they're convicted of a crime involving moral turpitude. Take that section out. I hope you don't say that. But I'm giving you the opportunity to tell me how you would change these specifications of misconduct so that we can be more clear on what is acceptable and unacceptable conduct of a prosecutor in this state. If you haven't, and you don't have to tell me right now if you don't know, but it would make your job easier if it was very clearly defined instead of just an appearance of impropriety. We could define what is improper.
The minute you start to enumerate very specific things, you then have an argument that anything you haven't listed isn't prohibited.
True.
And if you look back, I discussed in, I think it was 2022, when the original Prosecutor's Oversight Commission bill was proposed, they didn't list anything as a basis for discipline. And so I think it was just implied that they would use, all the canons and all. And so in making the list that's in the list, you now have a list.
It was negotiated.
And that's why I believe that we have to look at each situation and see if it fits into one of the enumerations. I don't think we could just say, and again, and I tried to make this point earlier, I work for the investigative panel. They can overrule my opinions any day of the week. But I don't think that we could just say, well, this is a violation of the Georgia Bar Rule so-and-so, and so even though it's not on this list, and I haven't done the analysis of whether it fits into the list or not, that we should be able to do this.
Okay.
They may disagree, but I don't think that's right. I think that we're limited to those items and anything that we can prove fits within them.
That is the truth.
Okay.
And that's what I'm asking you, should we list more enumerations to be more specific so it's less ambiguous to a prosecutor who might have their livelihood challenged here? Would it help? You've got this catch-all. Conduct prejudicial to the administration of justice brings the office in disrepute. That's very general, and it's who interprets particular conduct to bring you in disrepute or not. Would it be better for you if we had more specific enumerations in addition to that? You still have your catch-all, so it's including but not limited to, and put these actions. And if there are any in particular, would you just submit those to us in writing? Think on it. You're almost out of time.
I have
unless
no
there's something jumping out at you right now that you're like, yeah, I keep getting these complaints about A, B, or C, and it's not specific enough, and I'm limited in my ability to clean up bad actors.
I will tell you what would make it clearer for the public and for my commission is not the addition of anything, but maybe some clarification on the command authority responsibility for assistance, because that knowingly allowing or permitting,
Authorizing,
let's just say that some people are not happy when they hear that because this ADA did it and there's no proof that the district attorney even knew that case existed, that's it. I'm not asking for authority. I'm specifically not asking for authority over assistant district attorneys or solicitor generals, but that may need to be clarified for both the public and for the The other thing is that there is an interesting debate over the judicial system into disrepute. Does that mean that the media or social media or the loudest trumpet determines what a violation is?
Yeah. I would hope you're basing your decisions on evidence rather than social media, but
at some point, we have to prove
it
what.
does create this problem with the public perception.
But at some point, it would have to be proven, if that's where we're traveling, that it did bring the judiciary into disrepute.
Good enough.
So how do you prove that is my question to you.
I am going to discontinue my questions, and I'm going to turn the mic over to the minority leader, Senator Jones, if he has any questions to follow up. He may not, but by our rules and procedures, he has the right to ask any additional questions that he would like to. You're recognized, Senator Jones. Mr. Leader.
Thank you. I just had one, and you kind of laid it out, I think, within the paperwork that you gave us, but do you see any kind of pattern about what kind of charges are being brought consistently? I kind of see what some of the charges are. Are you seeing any kind of pattern? Is it by not following the law? We talked about that. Or is there a pattern about what kind of charges are actually being brought against the prosecutors?
There are actually several trends.
Okay.
One of the trends is, unfortunately, and I believe, people are upset, and people, some should be upset, some have the right to be upset, but we do get an awful lot of complaints from specifically mothers and grandmothers who believe that their child, usually son, was unfairly prosecuted, and that the prosecutor did this or that in the actual trial, and then the Court of Appeals let it go, or the Supreme Court let it go, and then the habeas, and then these are all lies. That is a trend. We get a good number of complaints about that. But again, you ask about the great number of dismissals that we have. Going back and saying that the Supreme Court was wrong in their decision of whether this evidence was admissible or should have been considered, that's not going to fly. And I'm not saying I'm unsympathetic to people whose children or grandchildren commit crimes and are punished. So that's a trend. Another trend that we get are, again, victims who are complaining, who base their complaints on it's been X number of years and we don't get enough communication. And then, so you're looking at, who controls the court dockets, who puts cases where, what are backlogs, what are the notification requirements. That's where the Crime Victims Bill of Rights / Marsy's Law has very specific rights and has its own enforcement mechanism right in the Crime Victim Bill of Rights, the ability to bring an action to petition the judge to address these issues. So that would be primary jurisdiction in Marsy's Law or Crime Victims Bill of Rights. But that is another trend. Another trend that we have seen this legislative body tried to address or addressed last session, that is the Giglio issue. Law enforcement officers, more than a few, have filed complaints saying that the prosecutor unjustly placed them on a Giglio list and cost them their ability to earn a living and that. And so that is a trend. Now there is, legislation was passed and it was amended several times, and hopefully that will help address the issue. But that is a trend. We just recently started getting quite a lot of what we would call jail mail. And I think you could figure out what that is. But you ask about trends. I talk about getting the word out. The word is out in a couple of jails, right? So, and I hope that answers your question.
It does, thank you.
Okay.
That's all I have.
All right, thank you so much, Mr. Leader. All right, thank you for being with us today, Mr. Heap, and I would also invite you to submit to the committee any recommended changes in the law concerning your qualifications commission or our underlying statutes that designate what is acceptable behavior by prosecutors or not. Any other recommended changes, if you would just submit those in writing to me, we'll put them in the record, and we will take those into account as we come up with a final report of the committee. Pleasure having you with us this morning. I know that was detailed. It is very educational to us to understand exactly how this process works.
Thank you for having me. I apologize for the length of some of my answers, and if I was in any way contentious, it was not any personal or contention. I'm just particularly detail-oriented, and again, I apologize for that. Thank you very much for having me.
Curse of being a lawyer. All right, you are excused, and we will now hear quickly from our counsel for the committee, Josh Belinfante. I think I have you as number 6. Is that your mic number? Can you see? You can just sit right there and talk through the mic if you want to. If you'd rather go to the podium, you can. It doesn't matter.
Yeah, if you can hear me, I'll just speak normally. I'm usually not close.
You're not mine.
Okay, all right, then, here we go. Is that working? Okay,
That's working.
all right.
We just wanted an update on our pending litigation. As we left it back in March, we had subpoenaed Fonnie Willis. She refused to comply. We had gone to Superior Court, and the court issued an order compelling her to attend, essentially upheld us on all grounds that we alleged our subpoena power and authority. And then that was appealed. We've been out of session since March. Tell us what's happened since then in that litigation, and if there's other litigation you need to update us on, the floor is yours.
So thank you. The briefing before the Supreme Court is now complete. After the district attorney filed her initial brief, we responded. She then filed a reply brief. And then shortly after that, the Supreme Court issued an order directing the parties to address whether the issue raised unique constitutional questions, because part of the argument was that the case was mooted when either the General Assembly adjourned at the end of the 2023-2024 General Assembly, or that the issue was moot when the General Assembly adjourned in 2024 and issued the subpoena while not in session. We did not discuss the response with the other side, but we filed very, very similar briefs saying that there are approximately 5 or 6 constitutional questions of first impression that established the Supreme Court's jurisdiction. We now have oral argument on Tuesday, November 4, and the Supreme Court has, under the 2-term rule, until I believe March of next year to issue an opinion in the case.
Okay. Now, you and I have been working closely together as we've been trying to arrange testimony in this committee. We have reached out to Fonnie Willis through her counsel, former Governor Roy Barnes, and indicated, in fact, we've already issued a subpoena that they had a complaint or a problem with the date. Educate my committee on where we stand on her testimony. Is she now consenting to willfully honor the subpoena and testify or not?
Yes, we had sent them a subpoena with a date for today's hearing. They got back to us and said that she was out of town today, or just couldn't work. I can't remember the precise reason. We have worked, and we think we have a date to have the district attorney appear. There's some questions about, and I think that her counsel would acknowledge service, so we don't have to go serve her individually and that kind of thing. I think there are some questions to work out in terms of the scope of questions that could be asked of the district attorney, given that there are pending lawsuits, prosecution lawsuits, not the civil ones. And we're having those conversations now, but we do think we have a date. We believe if she comes, that she will not assert an argument that because this General Assembly is not currently in session and the first session adjourned sine die, she will not be asserting an argument that that somehow voids or moots the subpoena. And if that's the case, then that would have potentially some impacts on the current litigation before the Supreme Court.
Okay. So that is my understanding from conversations I've been a party to or y'all shared with me, is that we will reissue the subpoena for November 13th, 10 a.m., and that her counsel has indicated that she is available on that date and will honor the subpoena, subject to certain limitations in the scope of questioning. And I think they also wanted to make clear that only the chair or the minority leader would be posing the questions. Of course, that's in our rules anyway, so that was not a problem. Am I accurately summarizing your communications with her counsel?
Yes.
Okay. All right, then we'll make a note that we'll be back here on November 13th at 10 a.m. expecting testimony from Madam D.A. Fonnie Willis. We may also have a meeting before then. We've talked to a couple of other potential witnesses, and I guess it's the chair of David Amani. What's his organization called now? It changes every year, it
State
seems like.
Ethics Commission.
State Ethics Commission now. He can share some information to us if we can find a date in October to do that. I feel a little bit of urgency to try to conclude as much as we can before the legislative session begins, because I'd like for this committee to have a report issued as to suggestions or recommendations as to additional amendments or new legislation. So we'll see what we can do. And is there anything else? Any other committee members have any questions for Mr. Belinfante? We good? Thank you for being with us, and thank you for your diligence in representing the committee.
Thank you.
With that, we are adjourned.